In the architecture of American democracy, the vote is the load-bearing structure. It is the mechanism by which the governed grant their consent and the tool by which we hold power accountable. But what happens when the very tools meant to secure that vote are weaponized into subtle procedural barriers? What happens when the highest court in the land seems aligned with the forces seeking to restrict access? This is the story of a constitutional confrontation fought not with marching feet, but with the sharpest instruments of legal reasoning. A battle that unfolded on the marble floors of the Supreme Court, centered on a single pivotal case, challenging a restrictive state voter ID law. Jackson, State of Verona. The central figure, Congresswoman Jasmine Crockett, arrived at this juncture not as a novice, but as a seasoned warrior of the legal trenches. A civil rights attorney by training, a public defender by vocation. Her career was a continuous fight against systemic injustice. From defending protesters pro bono to serving on the front lines of the Texas legislature, Crockett understood that laws look different on paper than they feel in marginalized communities. The legal terrain she faced was hostile. State legislatures, emboldened by recent court decisions that chipped away at federal oversight, argued from the text of Article 1, Section 4, the Elections Clause, that they possessed near absolute sovereign authority over the time, place, and manner of federal elections. For them, a voter ID mandate was a simple procedural regulation entirely within their legislative purview. Presiding over this philosophy was the clear posture of Justice Samuel Alito. His public remarks had signaled deep skepticism toward any expansion of voting rights, framing such efforts as unwarranted federal intrusion. In the context of a restrictive voter ID law, this judicial attitude implied that the state's right to regulate procedure would easily outweigh the minority's right to access the ballot. The Verona Voter Integrity Act was the test case. It demanded specific, government-issued photo identification. For communities already facing barriers, lacking easy transport, facing understaffed DMV offices, or holding outdated foundational documents, this law was less a measure of security and more a systemic choke point. Crockett's brief argued that this law, while facially neutral, operated with functionally discriminatory intent through its procedural design. But Crockett was prepared to demolish the premise of state supremacy. Her strategy was to rewrite the constitutional hierarchy itself. She was not challenging the state's procedure. She was challenging the state's license to discriminate through procedure. She invoked the power that followed the Civil War, the Reconstruction Amendments. The 14th and 15th Amendments, she asserted, were the ultimate constitutional counterweight. They were not footnotes. They were a fundamental revision, designed to guarantee that newly freed citizens would not be systematically blocked from the ballot box by the very same state actors who had just waged war against the Union. The right to vote, she argued, was now inextricably linked to the fundamental protection against the abridgment of citizenship rights. To prove this, Crockett eschewed modern legal theory for the weight of history. She presented compelling, painstaking research into the congressional debates of the 1860s. She brought the voices of the Reconstruction framers directly into the modern courtroom. Her evidence showed that the framers specifically intended federal oversight to possess supremacy over state discretion when the franchise was at stake, precisely to prevent disenfranchisement through indirect procedural obstacles. Her argument was revolutionary in its framework. These amendments were designed not merely to prohibit explicit racial slurs on a ballot application, but to ensure meaningful and practical access to the ballot for all citizens. This historical context stood in direct, unforgiving contradiction to Justice Alito's narrow 18th century reading of state power. Oral arguments began. It quickly became clear that this was not a routine hearing. As Crockett navigated the complex landscape of state administrative burdens, Justice Alito cut across her, assertively driving home the Elections Clause doctrine. Justice Alto spoke in a sharp, interrupting tone. Counsel, your entire line of reasoning hinges on the premise that the court may substitute its judgment for that of the state legislature regarding precinct hours and ID requirements. Is it not clearer, based on the explicit language of Article 1, that the state has the plenary authority here? Where precisely, in the text, do you find the authority for this court to override that procedural sovereignty? The trap was sprung. To answer directly on procedure was to concede the state's expansive reading of Article 1. Crockett let the silence hold the weight of the question for a critical beat. Then, she pivoted, using the moment not to defend her reading of Article 1, but to declare its subordination. Crockett spoke in a measured, rising inflection. Mr. Justice Alto, my argument is not predicated on substituting judgment, but on recognizing the constitutional constraint. Article 1, Section 4 is the general rule of procedure, yes, but the 14th and 15th Amendments are the exception of equality, designed by the very architects of the Constitution to correct historical abuses of state legislative power. They are not merely statutes, they are the supreme law of the land when liberty and the franchise are infringed upon. The framers understood that a state cannot use the manner of voting to achieve the prohibited purpose of disenfranchisement. The other justices took note. The historical documents she cited, the debates, the specific context of Reconstruction, were being absorbed not as dusty artifacts, but as living constitutional text. In a telling departure from typical judicial signaling, Chief Justice Roberts intervened, not to sustain Alto's objection, but to validate Crockett's scope of inquiry. Chief Justice Roberts spoke in a measured, slightly encouraging tone. Congresswoman Crockett, your historical citations regarding the 39th Congress's intent are compelling. Please take the necessary time to elaborate on how that intent translates into a heightened scrutiny test for procedural burdens today. We will extend your time accordingly. The extension was significant. It acknowledged that Crockett had successfully elevated the argument beyond procedural minutiae and into the realm of fundamental constitutional structure. She proceeded to paint a vivid picture of the consequences. The millions of eligible voters whose voices would be muted not by malice they could easily fight, but by administrative obscurity they could not overcome. Crockett was arguing for an inclusive democracy, one where the Constitution's ultimate promise, equality under the law, was made practical through the ballot box. She was demanding that the court move past the simple question of intent and enforce the reality of impact. When she concluded, the atmosphere was irrevocably changed. The weight of history, grounded in meticulous legal scholarship, had confronted rigid constitutional literalism. The stage was set for a landmark decision, a decision that would ripple far beyond the Verona state lines and even beyond the issue of voter identification. The court ruled 6-3 to strike down the Verona Voter Integrity Act. But the legal earthquake was just beginning. The majority opinion, penned by the Chief Justice, established a new framework. No longer would state election laws be given deference based solely on legislative convenience. Moving forward, any regulation impeding access to the ballot would face heightened scrutiny. The focus was fixed, not on the intent of the lawmaker, but on the impact on the citizen. The true measure of Congresswoman Crockett's success lay in the concurrence authored by Justice Samuel Alto. The justice who had so vigorously defended state supremacy was compelled in writing to acknowledge the limits. He conceded that the expansive authority granted under Article 1, Section 4 was indeed bound by the post-Civil War settlement. The Reconstruction Amendments provided an enforceable constitutional ceiling on state discretion. His concession was a stunning ideological admission, a forced reckoning with the historical arc of American constitutionalism. He recognized finally the supremacy of federal protection over state procedure when the franchise is genuinely threatened. The reverberations of Jackson v. Verona extended far beyond the immediate case. Legally, the decision revitalized an area of jurisprudence that many believed had been fatally weakened by prior rulings that dismantled federal preclearance mechanisms. Crockett's argument created a powerful new tool for civil rights advocates: disparate impact analysis as a constitutional test. This was the Crockett Doctrine, a framework demanding that legislative action regarding elections must serve a compelling state interest that cannot be achieved through less restrictive means, with access serving as the primary metric of restriction. Legal scholars immediately began dissecting and integrating this doctrine. Suddenly, every restrictive voting law enacted in the preceding decade faced a new, formidable legal threat. This wasn't about finding proof that a legislature was racist. It was about showing that their policy created an unjust, unequal barrier. The burden of proof shifted back, mirroring the spirit of the Voting Rights Act of 1965, but now secured by constitutional command rather than mere statute.